Welcome to Policy on Demand. I'm Scott McCandless. It is the week of June 24th, and this is your Monday briefing. The House is scheduled to be in session this week and out the week of July 1st, returning the week of July 8th. The Senate has already departed for a two-week Independence Day recess and will also return the week of July 8th. There are two tax policy developments of note. First, late last week, Senate Finance Committee Democrats said they would ask the Senate leader to put the tax extenders bill on the Senate floor after recess. However, it is not clear that a vote would be scheduled or that the bill would pass if put up for a vote. Second, with House Ways and Means Republicans and Senate Finance Committee Republicans already starting to look at 2025 tax policy with tax teams and working groups, the Senate Finance Committee Democrats now have joined the effort as well. Senate Finance Committee Democrats said last Thursday that they are working on a menu of tax provisions that they want to be in the conversation for the 2025 tax cliff debate. In political developments, it is 133 days until the 2024 presidential election, and the first presidential debate between current President Joe Biden and former President Donald Trump is scheduled for this Thursday, June 27th. It is yet to be seen whether any tax policy issues will be discussed during the debate. And finally, the Supreme Court issued its ruling in the Moore tax case, but has not yet released its decision in a case involving the Chevron doctrine that could have broad tax implications. Andrew Pryor had a chance to talk to Wade Sutton about the significance of the Moore case. Let's take a look at that interview now.
The U.S. Supreme Court on June 20th released its decision in Moore v. U.S., upholding the constitutionality of the Section 965 transition tax enacted as part of the Tax Cuts and Jobs Act. Joining us to share his insights on one of the most watched tax cases in recent history is Wade Sutton. Wade, welcome.
Thanks for having me.
So, I think maybe it'd be helpful for me and our viewers to maybe recap, what was this case about? And why was it so closely watched?
Yeah, so as you mentioned, this case was about the transition tax under Section 965. And basically what that was when TCJA was passed in late 2017, for certain foreign corporations, the earnings that they had accumulated that had not been subject to tax were basically subject to a catch-up toll charge tax as a transition into the new regime, which includes GILTI. And these taxpayers, they were two individuals, and they had invested a very small sum of money into an Indian corporation. They had a 13% stake. And when the toll charge rolled around, they were subject to tax on their share of the earnings of that corporation, even though, as they argued, they had no ability to compel that corporation to pay them dividends and they had not sold their shares. So their argument was, we had not realized income, and realization is a constitutional requirement under the 16th Amendment, and therefore the 965 transition tax is invalid as to us.
So the court rules on June 20th. What did they decide? And were you surprised? I know you watched the oral arguments. Were you surprised by the decision?
Let's take the last question first. I wasn't surprised because, when the case was cert was first granted, there was a lot of speculation about what they were going to do here. And there's press around, I think there's a Wall Street Journal op-ed the week or two before cert was granted that this was the slippery slope to a wealth tax. And I think, some speculated that may have been why the justices were interested in the case. But when we got to oral arguments, you kind of got a clear sense from some of the justices that they realized they had bitten off a very big issue that had some significant ramifications, and they were going to try and cabin the damage, or actually in the opinion, they say the blast radius of a potential decision in favor of the Moores. They ultimately didn't go that way, and they ruled very narrowly. You probably would say we have not learned much new from this case, at least from the majority's opinion, because what they said was, realization, we're not going to tell you whether or not that's a constitutional requirement or not, and we don't have to, because in this case, the corporation that we're talking about had realized the earnings, right? And the real question is whether or not it's fair to attribute those earnings to the shareholders, the Moores in this case. That's a due process issue, whether or not it's fair to attribute someone else's income to these shareholders. And the taxpayer did not actually raise that issue in the Supreme Court. Had raised it at the Ninth Circuit and did not preserve that argument. And so the court basically said, we don't have to touch that. We've got realization, it's fair to attribute. There are actually some cases from the 30s that stand for this principle, that it's fair to tax shareholders on the earnings of a corporation. So it was a really cut and dried case, you might argue, from the majority's perspective.
So with that in mind, they intended to be a narrow decision, but are there any insights about these broader issues about realization or any other issues that you can discern from the opinions themselves?
Yeah, I think there are, if you're really counting the votes closely, there were at least 4 justices who are on record now as saying that realization is a constitutional requirement. So that includes the dissenters, that was Thomas and Gorsuch, and then Alito and Barrett had a concurring opinion. The majority, right, did not weigh in as to whether or not there was a constitutional realization requirement. Justice Jackson did say that she thinks there is not one. So you've got these 4 unknown votes on this realization question. That's important because on the Hill, we've heard a lot of talk about potential wealth taxes, or, Senator Wyden has a proposal out there for mark-to-market taxation. Those things would tax unrealized income, or in the wealth tax case, property. And I think it's a fair inference from this decision that the justices would not be inclined to rule favorably on even a mark-to-market tax. And I think you're seeing some acknowledgement of that already from some of the progressive academic circles. And so maybe this case was not so important in the narrow sense about the constitutionality of Subpart F and the toll charge, but I do think it has some big ramifications for what Congress can do in the future.
Yeah. So we'll obviously keep an eye on that. But are there any actions that companies should be taking in response to this decision?
Yeah, it's funny. There are actions they should not take. I think a lot of companies were thinking if there is a favorable ruling in favor of the taxpayers, we will need to preserve refund claims to potentially get back the money we've paid under this 965 toll charge. I think that's all moot, and so we can forget about that. If I were them, though, I would keep an eye out for an upcoming decision in Loper versus Bright Enterprises. And that's a case that's revisiting Chevron. Chevron is the case about whether or not you should defer to an agency's interpretation of a statute and regulations. We've seen a lot of challenges to TCJA regulations over the last few years. I think if you go back to the Mayo decision in 2010, there's this awakening of administrative law in the tax space that maybe we didn't think the rules applied in the same way in tax, and we have now forgotten that. And just like the EPA, Treasury is subject to the same rules and strictures. And so whatever happens there is going to be very important, I think, for some of these regulatory challenges that are working their way through the system.
Well, thanks, Wade, as always, for sharing your insights.